of the indiplum principle implicates a party's right of access to court under Section 34 of the Constitution. We refer to Paulson, paragraph 64. It's accordingly submitted this court has jurisdiction on both bases, and it would be in the interest of justice to do from the English law. The point we seek to make is that a claim for a statement and abatement of account is simply not the type of claim to which the indiplum principle is applicable. The claim for statement and abatement of account is not a claim for an amount at all. It's a claim for a legal process which will ultimately reveal the amount owed, if any. As such, a claim for statement and abatement of account is not by its very nature a claim for an unliquidated debt. We refer, and we've given you an additional list of authorities, to Ogilvy, Thompson, J. in SA Fire and Accident versus Hickman, and we refer at 132E to 133B. And I shan't read the entire passage, which is relevant. We remind the court that that was an application for default judgment, and Ogilvy, Thompson, J. said, in the present case, the amount of the claim in issue is manifestly cannot be calculated today. That was the applicant tried to get default judgment that day. It will only emerge after debate of the count has been concluded. It is true that the claim itself is specifically enough, then so is a claim for damages, which by common consent constitutes an unliquidated claim. There are not presently in existence any fixed data from which the claim in issue can today be calculated. This claim will only become assessed or determined at the conclusion of the debate of account. As such, it is not, in my opinion, a liquidated demand. That judgment was quoted with approval in the appellate division in the case of Kleinlands v. Van der Westhuizen and O, which is on the additional list which we forwarded to you. Before Lord J. Grancy sought an order that there be a debate of the relevant Sharrig account and there be payment of whatsoever amounts appear to be due to the claimants upon plaintiff's such debate. This was so because no amount was known or capable of calculation at such time. It took years of litigation before Grancy even learned of the shares to which it was entitled. The Sharrig application was launched, if my memory is right, as long ago as 2008. Similar wording was sought before and granted by the SCA in the 2014 judgment. If my memory is right, that's Justice Maslansha's judgment. Again, no specific amount was claimed or ordered as information was not at hand to ascertain such an amount. The classic formulation of an unliquidated claim is to be found in Binswar J's judgment in Gustav Zeal Trading as Gustav Zeal Markelas and Old Mutual Life Assurance Company, where His Lordship referred to the Hickman case of Ogilvy Thompson J. Allied Bakeries versus Pizza and Fatties Engineering Co. and Vendic Spare, and stated, in both of the two first mentioned cases, the plaintiffs had claimed a statement and abatement of account and payment of the amount determined by such exercise to be due. Ex facie, the summonses in those matters, the amounts payable by the defendants were expressly unliquidated, hence the need for the accounting and abatement that was sought. And that's what we contend here. It's clear, therefore, that the indiplum principle simply does not apply in the context of claims for statement and abatement of account. It's therefore inapplicable to any of the amounts awarded to Grancy, since they were awarded pursuant to its two statement and abatement claims. And we make the point that the indiplum rule applies only to a rare interest, and the Etaquini municipality versus Regulum case makes it clear that it's confined to a rare interest and to a rare interest alone. Also said in Paulson. The Sharrig claim is unliquidated, as we shall point out. It's accepted that unliquidated claims do not attract a rare interest. The evidence about the process by which Grancy came to know that it had a claim in relation to the Sharrig investments and the process by which First, the High Court and then the SCA determined the extent of that claim demonstrate beyond dispute that Grancy's Sherry claim was an unliquidated claim. This court will be aware from the papers that Guwala took great pains to conceal from Grancy what had become due to it under the Sherry investment. He denied that any duty to account, originally any duty to account. Then he produced a 3-page account. Lord Law ordered him to produce a better account, Lord Law J. The account he produced in response was found by Traverso DJP to be wholly inadequate. All the accounts concealed the shares to which Grancy had been entitled under the Sherry investment. Pursuant to the order of Traverso DJP, Guwala finally delivered a 393-page account on 31 May 2016. This account was, however, still a fiction. It still failed to disclose the actual number of shares to which Grancy was entitled, and so intent was Guwala on concealing the truth from Grancy that he even had third parties alter their accounts and responses to them. In our new list of cases, we refer you to Standard Bank and Renico, where it's made that there was no, what the phrase is used there, mere matter of calculation, not capable of speedy ascertainment, and we say the Sherry is unlimited. The court came to a value judgment as to the date of the sale and the amount and the price at which it would be sold. It required days of oral evidence, assessment, etc. Based on all the evidence, the High Court and SCA themselves reached significantly different conclusions regarding the number of shares and sale price, which in turn differed from versions contended for by Grancy. The data in the final calculation was thus subject to assumption, and it could not be said that there was no room for uncertainty. This was not simply a mechanical exercise with known or easily ascertainable variations. We refer to Drake Flemmer, and we, in support of our argument that rare interest does not run on an unliquidated debt, and to the extent that you are not with us on Section 2A5, or with us on our contention that unliquidated claims do not attract a rare interest and are for that reason not subject to indiplum, the fact remains that Grancy's claims are unliquidated and as such are subject to Section 2A2 and 2A5 of the PRI. Grancy at all times claimed interest on its unliquidated claims from a date before the date of demand. As such, it always relied on 2A5. Interest in terms of 2A5 per His Lordship Justice Rogers in Drake Flemmer is not a rare interest, and the High Court and the SCA in this matter ordered interest to run on the Sherry claim from 2006 to 25 January 2006. There's no cross appeal against that being the date from interest should run, and that's not an interest before this court. And we refer to the B Shore Africa case, which is also on our list. Given that the Sherry claim is unliquidated, the interest on that claim from a date earlier than demand, as was ordered by the court, can only be interest in terms of Section 2A5, because interest in terms of Section 2A5 is not a rare interest, is not subject to the indiplum. Well, is the time up now? I've got 2 more minutes, okay. We are splitting the argument, and I have another 2 minutes. The respondents contend that to the extent that a development of the common law is required, it cannot be sought by Grancy because it was not pleaded. However, the issue of the development of the common law was fully debated before RAG AJ. The defendants did not at that time complain that the issue could not be raised because it had not been pleaded, nor did the court. Both sets of defendants argued the issue on its merits, both in their written heads and orally. They argued there was no justification to develop the common law, and the court considered and ruled on that issue. Before the SCA, the pleadings issue was raised, but the SCA nonetheless dealt with the matter substantively after it was fully traversed in written and oral submissions. We say that this aspect should be considered by this court. We are criticized on the basis that our proposed formulation of the common law is not specific as to the period over which the indiplum rule should not apply. The criticism is not well-founded or on a fair and proper reading of our submissions. As to the starting point, it is suggested that we fail to distinguish between when an account is due or when an account is sought. These are, however, from a practical perspective, one and the same. In most instances, the right to an accounting will not be fixed in time, but would be on request. As such, the account is due when it is requested. If a party refuses to account, refuting the existence of any such obligation or based on other defences, then the account may be produced only years later, despite having been sought and being due on request. To avoid ambiguity, we would suggest the wording "when an account is due" is preferable, as the seeking of the account renders it due when the seeker has a right to such account. And as to the end point, it is said that we refer to different stages of the accounting process. When an adequate account is furnished, or an adequate and accurate account, or a sufficiently accurate account to allow for quantification of a specific monetary claim. Our submission is that what is required is an account which is sufficiently adequate and accurate to allow such a specific monetary claim to be identified and pursued, and that is what was done before RAG AJ. During this period between the starting and end points, indiplum should not apply, and we say there are good policy reasons for this exclusion. Is it time to go? Okay, apparently I'm finished, and we just want to make one final point in paragraph 63 and 83 of Paulson. In the main judgment, it's made clear in our respective submissions that what is intended to be addressed in the indiplum rule are good faith defences to the claims flowing from statement and debatement. But we refer you to paragraph 63. Let me give you the paragraphs before I sit down. Paragraph 63 and 83 of the main judgment. Thank you.
Thank you, Justices. Grancy relies for its claim in respect of the Cape Gannet investment on the common law rule that precludes a fiduciary from making a profit pursuant to a breach of its fiduciary duty to its principal. If it does make a profit, says the principal, then that profit belongs to and must be accounted for or disgorged to the principal. That rule is known as the no profit rule, sometimes referred to as the secret profit rule. I'll come back to that. The no profit rule, importantly, is one of a pair of principles that applies in circumstances of a fiduciary relationship. The other principle is the no conflict rule. The two rules have been recognized by this court as separate and distinct rules. We refer in that regard to the Numsa versus Dunlop case of this court in 2019, which recognized the two core fiduciary duties are the no conflict duty to avoid all potential conflict of interest situations, and the no profit duty, which prohibits fiduciaries from obtaining any unauthorized profit for themselves that has not been properly disclosed or consented to by the beneficiary. We say it's important to distinguish between those two rules because the courts, our quo and our learned friends, we say, make a fundamental error in their analysis by running the two together. It's recognized that the rules were adopted into South African law from the equitable remedies available under the English common law that was stated by His Lordship Mr. Justice Hare in Phillips and Fieldstone. The no profit rule and the no conflict rules have not been uniformly formulated in our courts, but the formulation that's generally accepted is that of Innis CJ in the 1921 case of Robinson versus Randfontein Estates. I won't read that quotation, it's at page 177. It's the well-known formulation of the rule. In this case, we say all necessary elements for a no-profit claim are present. Firstly, Giwala and Manala are undoubtedly in a fiduciary relationship with grantee and owe grantee fiduciary duties. It's not in dispute that they owed a duty to grantee to use its funds exclusively for what is called the spearhead investment, and to manage that investment strictly in accordance with its terms, which precluded them from investing the funds earmarked for the spearhead investment in any other investment, such as the Cape Gannet investment. It's clear also that Messrs. Giwala and Manala breached that fiduciary duty. They speculated in this different investment, the Cape Gannet investment, and they did so without the knowledge or consent of grantee, as found by both the High Court and the SCA. And of course, Giwala and Manala received a profit from the Cape Gannet investment. Despite all those requirements being present, the High Court and the Supreme Court of Appeal held that grantee was not entitled to rely on the no-profit rule. They did so for four principal reasons. First, they held that grantee had to, but had failed, to show that there was a conflict of interest between it and the fiduciaries. It was held that their interests were aligned. Second, they held that the profit was not secret, because the Cape Gannet investment was publicly known about. Third, they held that grantee could not claim the profits made by Giwala and Manala because grantee had obtained its own share already through its shareholding in SMI. And fourth, they held that grantee couldn't rely on the no-profit rule because it didn't, when it became aware of the transaction, object to it or demand that Ingatana dispose of the Cape Gannet units. Our learned friends for the respondents essentially adopt those objections. We contend, with respect, that none of them provide a cogent reason for not applying the no-profit rule. Firstly, it's not a requirement of the no-profit rule that there be a conflict of interests between the principal and the fiduciary. That's important. We say that is a feature of the no-conflict rule, not of the no-profit rule. In any event, it can't be cogently argued that just because all parties profited from the investment, therefore there was no conflict of interests. If that were the test, then the deterrent purpose of the rule, that I'll come back to in a moment, would be lost. A fiduciary would be free to breach its fiduciary duty, provided the principal profited in some way from the unauthorized investment. Second, the reference to secret in the expression secret profit can be misleading. It's not a reference with respect to whether the principal had knowledge of the profit or not. It's a reference to whether the profit was authorized or not. That distinction is well made in the majority judgment of Lord Briggs in a very recent English decision relied upon by our learned friends in their heads of our argument, the matter of Rukadze, R-U-K-H-A-D-Z-E, decision of 7 judges of the Supreme Court. The relevant dictum: they are sometimes called secret profits, but the fact that the principal knows that they're being made by the fiduciary is irrelevant to the duty to account or disgorge. In the absence of the principal's fully informed consent that the fiduciary should keep them for his own account. We refer to that English case only because it expresses the principle well. It is also the principle in South African law, and we give the references at footnote 129 of our heads, particularly reference to the MMA Architects case in the Western Cape. And the distinction is also referred to in a useful article, also referred to by our learned friends, by M.F. Kasim. It's referred to at footnote 138 of the Giwala respondents' heads. I won't read it, but essentially it makes the same point that secret means unauthorized, essentially. Thirdly, while it is correct that grantee received some profit from the Cape Gannet investment, that is not, we say, a relevant consideration. It's recognized that the no-profit rule has what has been referred to as a prophylactic or deterrent purpose. It exists to dissuade the fiduciary from breaching its fiduciary duties. That purpose has also been emphasized in the English decisions, and we refer to the Rukadze case, where the learned judge refers to the essentially prophylactic role of the conflict and profit rules. And M.F. Kassim puts it well in her articles, the courts have traditionally applied the no conflict and no profit rules as strict and unyielding rules that allow little room for exception. The strict ethic reflects the vulnerability of the beneficiary to the fiduciary and the need to maintain the sanctity of fiduciary relationships of trust, confidence, and loyalty. The rigorous application of these rules by the courts is designed to be both prophylactic and deterrent. We say in this case, the application of the no profit rule as we seek it acts prophylactically by requiring Gowala and Manala as fiduciaries to account to Grancy for the profits that they earned on the unauthorized investment. The rule operates in that manner to sanction them for what His Lordship Mr. Justice Wallace in the Grancy case in the Supreme Court of Appeal described as their egregious breach of their fiduciary duties. And finally, there was no obligation on Grancy to demand that the Cape Gannet investment be undone. We say it's no part of the no profit rule that the principal must unwind the transaction which was concluded in breach of the fiduciary duty. In any event, Grancy couldn't have done so when it first came to know of the investment, as appears from the Cape Gannet subscription agreement, which the court will find at volume 2, page 123, clause 2.3.2. There was a 7-year lock-in, and it was an investment agreed between a number of parties apart merely from Ingatana. Mr. Mauji also made it clear in his evidence under cross-examination that Grancy's complaint about the Cape Gannet investment couldn't be made earlier than Grancy's particulars of claim, because until then, Grancy had been waiting for a full disclosure and an accounting. Moreover, we make the point that insofar as it's suggested that Grancy somehow accepted this investment or acquiesced in it, neither Mr. Gowala nor Mr. Manala, through their legal teams, pleaded in response to our Cape Gannet claim that Grancy acquiesced in the investment or waived its right to claim. They were neither pleaded nor proved, and obviously evidence would have had to be led in that regard. So the fact that Grancy did not require Ingatana somehow to exit the investment provides no defense. The rule has universally been described as a very strict one which allows little room for exception. His Lordship Mr. Justice Hare put it this way: the defences open to a fiduciary who breaches his trust are very limited, and he speaks then of only one. Only the free consent of the principal after full disclosure will suffice. And as this court will know, a consistent feature of all Grancy's litigation against Messrs. Gowala and Manala has been a complete lack of honest and frank disclosure by them. And it's common cause that there was no disclosure or consent in relation to the Cape Gannet investment. In the circumstances, our submission is that all the elements necessary for the operation of the no-profit rule are present: the fiduciary duty, an egregious breach, and a profit made by the fiduciaries. And the single available defense of free consent obviously does not apply. The inevitable consequences, we say, of the operation of the no-profit rule must follow, and Messrs. Gowala and Manala must disgorge to Grancy all the profits that they have already and will in the future derive from the Cape Gannet investment. Thank you, Justices.
Thank you, Mr. McNally. Mr. Hodis, am I correct that to see whether a case has been made out that we have jurisdiction, we've got to look at your pleadings?
Well, we contend that this is covered both by argument in the courts below and was addressed and dealt with. You're talking about jurisdiction in this case, in this court?
I'm looking at paragraph 22 of the founding affidavit. In fact, it's paragraph 22 and 23 and 32. The common theme in those paragraphs that Grancy says the SCA is guilty of misapplying the law pertaining to...
Give me a moment, please, Justice Lumber. Is this under the page 7 under the heading Spearhead Agreement? Sorry. Could you give me the page, please, Justice Mlamba?
You want the page number?
Please.
Well, the page number of your founding affidavit in the record is 1792.
So that, sorry, that is the page number before this court.
Yes.
Yes. 1792. '23.
22, 23, and 32. But let's stick to 22.
Okay, thank you.
Yeah. The case made out there is that the SCA is guilty of misapplying the law.
Yes. As to secret profits.
Yes.
Yes.
Does that found our jurisdiction? Hasn't this court said the opposite?
I thought I covered that in my argument a bit earlier today. This is an incorrect legal standard that was applied.
Yes.
And that does take up this court's jurisdiction.
That, well,
Well,
you
I referred,
wanted
for
different
instance, to-
argument in the heads.
In the heads,
Yes.
but I thought I took you today to Lewis Stores, which addresses that. And maybe, let me just find my note here for the moment. We do say in paragraph 22,
Yeah.
the second half of the sentence, we say, it grants the request the court to correct the SCA's misapplication of the law pertaining to secret profits, where the SCA misconstrued existing law or created new law. And we contend that would surely be a matter for this court's jurisdiction.
But you say that in the heads, not in the founding affidavit.
I'm sorry, I'm reading our affidavit. I've just read to you from our affidavit, where the SCA misconstrued existing law or created new law. That's what you referred me to. You referred me to the first half of the sentence.
I see.
The second half of the sentence says, where the SCA misconstrued existing law or created new law.
Yeah.
And then I go back to, for instance, Lewis Stores. If I could just find my note here for the moment.
From there.
We made the point, and I made the point today, that you'll find our arguments on jurisdiction in our heads. Do you want me to take it there, or do you know it's that page, paragraph 128? By the way, are we now dealing with the court's questions?
Yes.
And then my learned friend will argue after the question.
Yes. After you've dealt with our.
Sorry, I didn't realize. Sorry, my learned friend. Yes, sorry. You're 100% correct, yes.
Okay.
Have I answered your lordship's question?
Well, I've heard your response, Mr. Holders. Thank you very much.
Thank you.
Mr. Hodges, in your written submissions, you also say that the SCA failed to develop the common law regarding the application of the indiplum principle.
Well, can you tell me where so I can find it, lady?
Where in your written submissions,
Yes,
paragraph 19.5,
19.5,
19.5,
at page 7.
page 7.
In failing in the alternative to the extent that indiplum would otherwise apply under the common law in any way, to develop the common law, we say it would apply, but in any way, in the alternative to develop the common law regarding the application of indiplum in the context of statement and debatement of account matters and comparable circumstances.
Well, let me ask the
Yes.
question. what I wanted to find out, where you complain about the SA having failed to develop the common law, what I'd like to know is, was this issue or this argument properly ventilated in the SA? Was the issue of the development of the common law properly pleaded for the SA
The
or the High
alternative,
Court to delete?
the alternative argument, the first argument was definitely. Yes, yeah, but the second leg. The development of the common law was definitely developed in both courts as well.
My understanding of the judgment at para 218, that's volume 20, page 1906, the judgment of the SCA.
One nine oh six.
1906, para 218, where the SA dealt with this question of the development of the common law. It says that the applicants failed to plead that the common law should be developed.
So we failed to plead it.
Yes.
We failed to
And
plead
it
it, but
also said-
we argued it. We argued it before RAG,
Shouldn't-
AJ, and in detail. And we argued it in detail before Justice Skippers. And he didn't refuse to let us argue it. He dealt with the argument.
Shouldn't it have been pleaded in the papers?
Now, we
And-
do not put in issue that it should be pleaded. And we do say, though, however, we contend, it was argued in detail.
Both in the
And
High
it
Court.
is a legal issue. It's a legal issue. And
Was
it's
it-
open to us to argue it today as well. We say, firstly, before saying it's a legal issue, fairness dictates that the matter should be addressed by this court. It was argued in detail before RAG, AJ, and before Skippers, JA, the SCA, and we say it is a legal issue which falls to be dealt with by this court if it has jurisdiction, which we
So-
contend it does.
Okay, so you disagree with the argument that set out, or the finding of the SCA in that paragraph?
And we disagree with what Skippers JA says in paragraph 27, that the argument is opportunistic and artificial, and it was understandably not pressed before us, is incorrect. Let me say that unreservedly, that it wasn't pressed before us is incorrect. We pressed the argument.
Thank you.
Thank you.
Mr. Holders. Still in that paragraph that Justice Mhlantla referred you to, the SCA says that to entertain that issue would be prejudicial to the respondents.
Sorry, I can't find that one.
1, 2, 3, 4 from the bottom. The line 3, 4 from the bottom.
This is such a case. Is that
1, 2, 3, 4.
from the bottom?
Yes. Second, it is
And third is,
undesirable.
it's the legislature and not the courts which has the major responsible for law reform.
The line before that saying.
This is such a case.
It says second. 1, 2,
Oh,
3,
sorry,
4,
sorry,
5,
sorry.
6, yeah, it's actually 6. I also misled you, it's 6 from the bottom. It says second, it is undesirable for an appeal court to develop the common law as a court of first and last instance. It must consider whether it would be unfair or prejudicial to do so, based on the pleaded and established facts. This is such a case, a development of the indiplum rule would prejudice the respondents. This is what I'm referring to.
All right, let me just deal with that. I just want to ask my learner friend to find me, there is a constitutional court case where it develops the common law in the first instance. You'll find it. There is a judgment of this court where it develops the common law in the first instances, and I'll ask those around me to find it for me. Now, why would it be undesirable? He doesn't say why. It is undesirable for an appellate court to develop the common law as a court of first and last instance. It may not,
My interest is on the prejudice. I'm sorry to interrupt you. My interest at the moment is on the prejudice, what the SCA said would be prejudicial to the respondent.
and I contend that there would be no prejudice. It would be maybe a suggestion of prejudice if we sprung it for the first time in this court. It was argued in detail before RAG AJ, and it was argued in detail before the SCA. And there can be no prejudice to them. They actually argued it and argued as to why it was wrong. So I contend, with respect, that there would be no prejudice. The development of the indiplum rule would not prejudice the respondents who appear before you today. And the fact that, if I could just remember which case in this court also found it would be quite satisfactory for the court, and particularly this court, to develop the common law. Yes. Could I take you, it's been referred to at page 2034 in volume 21 of these papers, judgment of RAG AJ, paragraph 369. I do not find that the debts owing to grantee are unliquidated, and that consequently section 2A5 of the PRA Act does not apply. Then grantee contends that the common law should be developed in the context of statements and debatements of account, such that the indiplum principle is suspended from the date that the account is due until the date that an adequate account is delivered. The Gawali defendants, however, contend that all of the claims are liquidated, etc. We know that that was argued before RAG, and there was no suggestion that the respondents couldn't address that.
Okay, thank you. Thank you, Mr. Holders. I'm interested in hearing your submissions concerning the submission by the respondents, specifically the Ginwala respondents, where they say that the claim is liquid.
The claim is?
Liquid.
I have argued this
Not
morning.
unliquidated.
I've argued this morning, so let me, if I can get my note and take you to our heads if necessary. I'm going to take you, we know that this
You're going
is...
to take me to,
Sorry, of course.
are you going to take me to answer why it is liquidated, why it is liquid?
Why it is illiquid.
Yes,
Isn't that what you wish me to do?
yes.
Well, I'm going to take you in a little bit more detail then to the judgment of Ogilvy Thompson, which which I referred to as he then was in the Cape a long time ago. SA Fire and Accident versus Hickman. It's in that list I gave you. His Lordship says, in Pretorius v. Herbst, Blackwell J. held that a claim for payment of such sum as may be found to be due after debate of account does not constitute a liquidated demand within the meaning of Rule 42T, which latter defines liquidated demand as a claim for a fixed or definite thing. Blackwell J. expressed the opinion that the claim in issue did not reach the stage of being for a fixed and definite thing until the account had been presented and debated and a sum arrived at. The Encyclopedia of the Laws of England states that in order for a to be a liquidated demand, a claim must be so expressed that the ascertainment of the amount is a mere matter of calculation. That I would ask you mentally to underline, a mere matter of calculation. And that correctly reflects our own practice as I understand it. That was a matter, my lady, Justice Cheeky, where the court was to hear an application for an unopposed default judgment based on a statement and debatement of account. In the present case, the amount of the claim in issue manifestly cannot be calculated today. It will only emerge after debate of the account has been concluded. It is true that the claim itself is specific enough, but then so is a claim for damages, which by common consent constitutes an unliquidated claim. There are not presently in existence any fixed data from which the claim in issue can today be calculated. This claim will only become assessed or determined at the conclusion of the debate of account. As such, it is not, in my opinion, a liquidated demand. That is one answer. That case was referred to with approval and was quoted in extenso in Kleinans versus Van der Westhuizen NO, in a judgment which is in the additional list. And we make the point that we told you before Lord Law, we ask for payment of whatsoever amount appears to be due to the plaintiff upon such calculation. And I've given you...
Can I then check if I understand you? You're saying that for it to be liquidated, it must be ascertainable.
More than ascertainable. It must be a matter of mere calculation. What is readily and speedily ascertainable? And I have given you this morning, and I don't want to unnecessarily repeat myself, but there's the judgment of Sutherland J. in Standard Bank and Renico, where he says it's a statement of the debatement matter, and he says the data upon which the calculation to be based would have to be amounts about which there was no room for uncertainty, estimation, or debate. That was for it to be liquid. When in order to prove his claim, the plaintiff will have to show that it or some element in it or some data involved in its computation was fair and reasonable. The claim is not liquidated. As also said by Binsward in the Gustav Zeal case, which I referred to this morning, dealing with the same question. Ex facie, the summonses in those matters, the amounts payable by the defendants were expressly unliquidated as statement and debatement matters. Hence the need for the accounting and debatement that was sought.
So we say that all our claims are liquidated because they are subject to statement and debatement.
Yeah, well,
But we also say that the sharing claim is clearly unliquidated.
what is this now? Yeah. Could I take you for a moment and to just summarize? This is one passage I didn't have time to make out of my notes this morning, but we make the point that at least Sherrick for sure is unliquidated. The Sherrick claim we contend is unliquidated. It required a protracted investigation to uncover the existence of the millions of shares on which the claim was ultimately based. Then it had to be determined essentially on an assumed basis. There was no evidence as a fact that they were sold on the 25th of, or would be sold on the 25th of January, or at what price, when those shares would have been sold and at what price. This was a value judgment, a point I made this morning, resulting in essentially a best guess or reasonable estimate reached after considering a multitude of facts. It required days of oral evidence, assessments as to credibility of witnesses, and then a judicial determination as to, one, the number of shares which should have but never did vest in grancy, two, whether these shares would be sold in one or more, or two or more tranches, the date of the sale, and the sale price. Based on all the evidence that was led, the High Court and the SCA themselves reached significantly different conclusions regarding number of shares and sale price, which in turn differed from the versions contended for by Grancy and the Gawala camp. The data in the final calculation was thus subject to assumption, and it could not be said there is no room for uncertainty, estimation or debate. This was not simply a mechanical exercise, which it had to be, with known or easily ascertainable objective variables. The claim, Justice Cheeky, does not meet the requirements for a liquidated debt.
Thank you. Thanks, CCT.
Mr. Hodges, can I ask when, on the basis that a claim for an account is not itself a liquidated demand, at that stage, is it a claim for an amount of money at all?
The customary way to plead it is for statement of abatement, and it customarily ends, and to pay what is found to be due. Yeah.
That's what I'm asking. At the time that the account is demanded, it is not a demand for either a liquid or an illiquid amount.
Correct. But at the very least, it's not a demand for a liquid amount.
And if it's not at that stage a demand for any amount, whether liquid or illiquid, what is its character once an accurate account or an adequate account has been furnished, leading to the quantification of a monetary claim? Is that claim then illiquid or liquid?
Well, it's quite interesting, and I want to think that through, I must admit that, because Justice Mslancha's order for the SCA, you may remember, we went before McDougall AJ, who said it must be debated among ourselves, and we thought that was suicide. We then went to the SCA, and the SCA ordered that it be debated before a judge, which happened. But in the order of the SCA, it says after the debatement, a document in the form of particulars of claim, not particulars of claim, must be issued. And clearly, at the time of issuing it, we would seek an amount.
What I'm really trying to get at is, in order to get into any parts of Section 2A of the Prescribed Rate of Interest Act, there must at some stage be a demand or a claim for an unliquidated amount. Now, if the demand for the account itself is not a demand for an amount at all, but for the initiation of a process that might give rise to the claim for an amount, then the claim for the demand itself doesn't bring one into Section 2A. If once an adequate account is furnished, there are then quantified claims. And if those claims at that point are claims for liquidated amounts, you also don't get into Section 2A.
But if they...
The reference to the Ogilvie Thompson judgment, I think, was somewhat, it wasn't referenced in the written arguments. I'm trying to tease out the implications of its correctness for the interest question in this case.
Yes. Now, I can't remember all the facts in what we call the Hickman case. There may, in fact, taking into account what Ogilvie Thompson J says, there may have actually been an amount mentioned. But I can't swear to that. But the situation here is, once the accounting was sufficiently satisfactory, but not perfect in any event, we then issued the document in the form of particulars of claim, whereupon the amounts were set forth in the particulars of claim. The fact that they are set forth in the particulars of claim does not make them liquid amounts.
There might have been a claim for, on your argument, for unliquidated amounts when the particulars of claim, I leave out the word form of, were served in 2016.
Yes, that's the point I'm making. And in fact, we could never have known yet what came out later. We never knew of the extra shares that Giwala got. You may remember it was subsequently found out.
Yes, now, I don't want to go into the merits of why
Yes.
it might at that stage still have been unliquidated.
Yes.
Assuming that to be so, you said arrear interest doesn't run on a claim for an unliquidated amount.
Yes.
Now, in terms of Section 2A, subsection 2, surely it does from the date of demand or summons.
Yes.
Do you accept that the indiplum rule would apply to arrear interest that runs from demand or summons under Section 2A2?
But that's not a rare interest.
Well, it says it runs from the date of demand, so what else is it if it runs from the date of demand? The point about not being a rare interest, if you are referring to the matters I considered in Drake Lemma,
Yes.
was concerned with the character of interest, additional interest, which the court in its discretion awarded under subsection 5.
Yes.
But I don't think there was any question that the interest under subsection 2 is a rare interest and is in principle subject to induplum.
That's not addressed directly. But we do contend on a reading of your judgment, Justice Rogers, that it appears that a rare interest is not applicable in that 2A2 instance. We have referred you to a judgment by Turner AJ. Could I just try and find that? Can you?
I would be interested to know if there's any authority that suggests that interest that runs from demand or summons under subsection 2 of 2A is not a rare interest, because I would have thought self-evidently it was, but if there's authority to the contrary, I would like, it would be useful for the court to be referred.
Show me the passage. Just could I just, I'll come back to this for the moment, but could I give you the reference to Cruz versus Bernardo, 2022 2 SA 185, particularly at paragraph 57.
2022 is the South African law report.
Yes, 2022 2 SA 185 GJ, and I refer to paragraphs 57 to 60, but I shall or my learned friend, Mr. McNally, will deal with that in reply.
Your opponents criticize your argument on induplum and interest in relation to the spearhead claims on the footing that they're just a couple of paragraphs, as if everything that is said on the Scary claim applies mutatis mutandis to the spearhead claim. Now, leaving aside the Scarlet Ibis and Cape Gannet elements of the spearhead claims, there were 25 spearhead claims.
Yes.
And I don't see any submissions as to which of those, if any, were unliquidated. For example, the late payment of dividends, or the non-payment of dividends, or the payment of administration fees disclosed in financial statements, or the non-payment of interest earned in the HHG trust account. It seems to me there are a substantial number of claims there that are almost certainly liquidated.
Correct. I don't argue with that.
Well,
But we are still dealing with a statement and abatement of account.
Yes, well, I'm not sure if you need a statement. I'm not sure you can, as it were, shield from the ordinary rules amounts that you were in a position to claim without a statement of account.
What you're saying, Justice Rogers, we could have issued summons for those amounts.
If you found that a dividend was issued and declared, but your share wasn't paid, you could have issued summons for it.
I can't argue with that, and I won't argue with that.
What would be useful, I think, and subject to the presiding justice, the Deputy Chief Justice's approval, it would happen after the hearing, would simply to have a schedule without any argumentation of the dates from which you say interest runs and under what provisions of Section 2A, if that is the...
On the spearhead claims?
On all of the claims. In other words, presumably these arguments are advanced on the footing that you may succeed. So if you may succeed, yes, we must know what we have to award you. So it seems to me it would be useful to know for each claim, Scarrig and all the spearhead claims, in respect of which of those do you pursue an appeal, and what are the precise dates based on what you told us this morning as to when induplum is suspended and when the suspension ends,
yes,
what the relevant dates are for each claim, and for what portion of that period induplum you say is suspended.
We'll happily do that, Justice Rogers, and we'll do it swiftly.
Yes. I do have questions for your colleague, but I think we, for the moment, dealing with indiplum and interest.
Thank you, Mr. Hoders. On the question of jurisdiction in respect of the interest claim, you rely on this court's judgment in Lewis, which in turn refers to this court's judgment in Villa Crop,
Yes,
that proceeds from the premise that if the court applies an incorrect legal principle or standard,
yes,
that would constitute an error of law. It would potentially violate parties' right to access to court, and it would engage this court's jurisdiction.
indeed.
Now, in the light of that, the authority of this court is also that where the court proceeds from a correct legal principle or standard, but applies that incorrectly, that would not engage this court's jurisdiction. Do you accept that?
I do accept it. It's been stated.
Now, in paragraph 3 of your founding affidavit in the application for leave to appeal, paragraph 23, sorry.
Just give me a moment, Justice Collopin.
Sure.
At page,
It would be at page 1793 in volume 19.
thank you, paragraph 23.
That's correct.
Yes,
It said there under oath that second, Grancy approaches this court to correct the SCA's erroneous application of the law on unliquidated debts. I just want to pause there, because what appears to be the case, if one has regard to the SCA judgment as well, is firstly the SCA appreciated the difference between a liquidated and an unliquidated claim.
it did it very poorly, with greatest respect
No,
to justice.
what I'm saying is that it recognized the difference.
Yes,
It recognized that that difference was quite material in its own conclusion. But on your argument, what the SCA then did is that it incorrectly concluded that on what was before it, the claims were liquidated claims. Is that not so? It erred in that.
yes, but did it not apply the incorrect standard in so doing?
No,
That's what we say.
on the facts before it, it said they should have known. Those are all factual.
No, but there's a legal standard.
The legal standard was a correct one, but on the facts before it, on your argument, it reached a conclusion that it could not have reached.
We do not accept, Justice Collopin, that the standard was correctly stated.
Okay, could you point to me where
Well,
you
I
say-
need you to point me where you say it was correctly, then I can deal with that. Isn't that better?
Well, I'm saying that for two reasons. The one, in your own application for leave to appeal, you characterize the problem as the erroneous application of the law. You don't characterize the problem as an incorrect legal standard was used, but rather that the law was erroneously applied or the law was misapplied, as the case may be.
But we do say today that the incorrect legal standard was applied.
So are you saying that today?
Yes.
Okay.
I thought I did say it
Mr.
earlier.
Cheeky had pointed out to you that the jurisdiction of this court is based on the pleadings before it. And on the pleadings before it, certainly the founding affidavit would suggest otherwise. But anyway, let's leave that. When you say that the SCA got the law wrong, in the SCA's own judgment, where they deal with interest,
Can you give me the page reference, please?
sure. Page 1908, volume 20, and at paragraph 222.
You say page 2008,
Page 1908,
1908.
volume,
I have it.
paragraph 222. Right at the top of the page. So what the SCA says, and with which you disagree, is that all the appellant's claims are for liquidated amounts, as the High Court rightly held. These claims were either quantified in the particulars of claim or capable of prompt and speedy ascertainment. You disagree with that,
Absolutely.
and understandably so,
Yes.
but you disagree with the factual conclusion that the SCA reached based on an incorrect application of the law.
Yes.
There's nothing to suggest that the SCA applied an incorrect legal standard, and certainly your application for leave to appeal doesn't advance that case. What do you say about that, Mr. Otis? Why should this court then be satisfied that its jurisdiction is engaged?
I
at least
see
in-
somebody moving behind me on the right here, so I don't want to cut him off. What do you want to say? What's the correct legal standard? Indiplum doesn't. Can you find me where it said it did? I'm told, and I'll try and find it by my learned friend, Mr. McNally, that there was a finding by the SCA that the indiplum rule would not apply, and it would apply to a statement and debatement of account. I'll find that, and that would be an incorrect standard of law being applied.
Okay, let's leave it at that. Thank you, Mr. Otis.
I'll try and find that for you. Okay, we have it, I have it. At, well, now I have to take you to, if I could take you to 1794. This is of our founding affidavit.
Yes.
23.3 says the SCA erred in misconstruing the notion of a claim for an unliquidated amount, etc. Third, and only to the extent that grantees' relevant debts are indeed claims for liquidated amounts, the SCA erred in its application of the law to the indiplum rule. The indiplum rule does not apply to claims brought in the context of statement and debatement of account proceedings, and certainly not until a fiduciary has delivered a full and proper account, and we contend that that is applying the incorrect standard of law.
Sorry, you said
There's
you were
another
from,
paragraph, I'm told.
from page 1794, paragraph 23.3.
Yes, Justice Colvin, and give me paragraph 24.
Yes, but that goes to the argument that you and I had, whether in
Yes.
fact the SCA got it wrong on the facts.
Yes, no, well, this widens it. Could I take you to 1791 while you were there, Justice Colvin? Grancy, paragraph 20, Grancy contends that the SCA erred in two respects, namely, in one, misconstruing and reshaping potentially inadvertently the law regarding secret profits in this context of an unauthorized transaction in the spared investments, and two, committing a fundamental error of law in mischaracterizing the nature of certain of Grancy's claims of finding unliquidated claims to be liquidated, which then precluded the awarding of interest regime in terms of sections 2A5.
Okay.
You say paragraph 24.
Mr. Hodes, I don't want to go for this to extend unduly longer than is necessary, but certainly in 20.2, your complaint there is the finding by the SCA of an unliquidated claim to be a liquidated claim. That is how you characterize consistently your,
Yes.
your fault with the
Is it?
SCA's conclusion that it
That is correct.
implicitly concluded that an unliquidated claim was in fact a liquidated claim.
Yes.
And that's not an error of law, that's an error of fact.
We contend it's an error of law.
Thank you,
I can
Mr.
do no better than that.
Thank you, Mr. Otis.
Thank you.
Mr. Odes, if I may follow up on the question that was asked by Justice Scalabrini. In relation to the other claim for, so there's two claims, there is
Sharing and Spearhead.
in relation to the secret profit claim,
The secret profit claim.
yes, which you did not address.
No, Mr.
Yes, I just want to make an example.
Yes,
Because there I was at least able to get a sense of what was meant by an application of a wrong legal principle.
yes.
Contention there was that there is a no profit rule, there is a no conflict rule. The Supreme Court of Appeal conflated the two and applied the no conflict rule when in fact it should have applied the no profit rule. And that clearly goes to the application of the legal standard. But in relation to the indiplum rule, just explain for me what legal rule should have been applied, which was not applied. Because as the previous question was put to you, in my view, the SA appreciated the difference
That,
between an unliquidated claim and a liquidated claim, made a factual determination from which then it applied the applicable legal rule.
thank you. What do you want to? Sure. I thought I'd made the point to, sorry, I was nagged over my right again. The error of law that we refer to was made by applying the indiplum rule to a statement of, by applying an indiplum rule to a statement of debatement of account. And that is impermissible. And we can say was purporting to adopt an incorrect legal standard.
Okay, I think that's it on jurisdiction. There's a question. Oh, sorry. There's Opperman has a question. Sorry.
Do I understand your position in regard to the arguments relating to the common law and the development of it to be, as recorded in paragraph 102 of your heads of argument,
Yes,
where you say that it was fully ventilated before both Judge Ragg, Acting Judge Ragg, and in the Supreme Court of Appeal. In footnote 93, you reference your heads of argument in both those courts where this argument was advanced.
could you give me a moment just to find what you're referring to?
Paragraph
102, you say?
Yes.
Yes, Justice Opperman?
Yes, so you've referenced the heads of argument both, and it's in the part of the appeal record,
Yes.
both in the High Court and the Supreme Court
Yes.
of Appeal,
Yes.
where your arguments were advanced in relation to the development of the common law.
Has it that?
And then the point is made in paragraph 102 that the actual development sought is not a factual issue, but is a legal matter implemented through the application of judicial policy.
Yes.
So would that then be open? I mean, would we, it was argued, it was not dealt with, but the courts below were afforded the opportunity to weigh in.
Yes, but
They didn't.
by choosing not to do, they were guilty of error in law and applying an incorrect legal standard. That's my answer to that, Justice Opperman.
Thank you.
Thank you, Mr. Hodes. Mr. McNally, I think there's a question for you.
Sorry.
Mr. McNally, speaking for myself, I accept that our law should accept, and perhaps does already accept, that the conflict rule and the profit rule are separate rules. The profit rule may be engaged despite the absence of a conflict of interest. The way you formulated your proposition of the profit rule was that the fiduciary may not make a profit from a breach of a fiduciary duty. It seems to me from the authorities, including the latest Supreme Court judgment from the United Kingdom, that there doesn't need to be a breach of a fiduciary duty. The simple principle is that any property, in its broadest sense, that the fiduciary obtains by virtue of his fiduciary position belongs in equity to the principal unless, with full informed consent, the principal has agreed otherwise.
With respect, I agree with that.
And of course, in the vast majority of cases, the profit rule applies where to ordinary trusts. The trustees always accept that they must account for profit to their beneficiaries, and most of them do.
Yes.
And there's no breach. It's just the rule that what you receive in your fiduciary capacity must be accounted to your principal.
It often would be a breach, of course, in practice.
There would often be a breach.
Yes.
It doesn't have to be.
Yes.
The rule doesn't turn on breach.
No.
Now, what seems to me to complicate a case like this, and I would appreciate reference to any authority which deals with something similar, is this. The profit rule, as I've just summarized it, rests on the principle that the fiduciary owes a single-minded duty of loyalty to the principal and must only see to the principal's interests, not his own. And that will often, mostly, perhaps in the decided cases, apply, because that is the only position which the fiduciary occupies. But this case is different because, or a case like this is different, because Mr. Gawala and Mr. Manala, although they had to deal in good faith with Grancy as their co-shareholder in SMI, had their own, and were known to have their own financial interests in SMI. Anything they did for the benefit of SMI would inherently benefit themselves and Grancy, and anything that was to its detriment would be to their prejudice as well as Grancy's. So it seems to me one can't simply transpose the notion of single-minded loyalty,
Yes.
in this case, to Mr. Gawala and Mr. Manala in this case. To put it this way, a lot of the authorities in England say effectively the fiduciary, if he was to acquire the asset or benefit at all, had to do so for his principal solely and not for himself. But in this case, the Cape Gannet transaction was never something in regard to which you could say that Manala and Jawala had to acquire it, if they acquired it at all, solely for Grancy's benefit. If it was to be acquired, it was to be acquired for SMI, or via Ingatana to SMI, and inherently, therefore, for the benefit of all three shareholders, in considering any transaction by which SMI might benefit. They inherently had to be considering their own interests as well as Grancy's. Grancy, if they had come to Grancy before the Cape Gannet transaction was undertaken with SMI's approval and said, this is what we are wanting to do, Grancy could never have said, yes, but you are my fiduciaries and therefore I must get 100% of Grancy. Grancy could only have said, well then, that's fine, but obviously I'll get my third benefit as a shareholder in SMI.
Yes.
So I battle to see how the profit rule can apply in a case like this to compel Manala and Jawala, who were always known to be interested to the extent of 2/3 in SMI's affairs, to account for anything other than the 1/3 to which Grancy was entitled. That was, to put it differently, it seems to me that their fiduciary duty towards Grancy was confined to dealing in good faith with Grancy's 1/3 interest in anything affecting SMI and its subsidiary could never have been a duty which required those two parties to see that grantee got everything.
Yes, Justice Rogers, we accept that that's a complicating feature, and you asked for authority to assist, and we found none that would assist in that particular aspect. Our reasoning is this, that it would be incorrect to conclude that the fiduciary duty owed by Manala and Gowala to grantee was confined to the 1/3 investment. And the reason for that is that the spearhead investment was always understood to be a unitary investment involving a pool of funds. And therefore, it was incumbent on the people running that investment to run it only in accordance with its terms, which meant that that pool of funds could only be invested in the spearhead investment. As soon as they invested the pool of funds into another investment, they breached that fiduciary duty, the fiduciary duty being a duty in respect of the whole investment. And as soon as they do that, our reasoning is, and we accept, this is what the High Court and the Supreme Court struggled with as well, is exactly the problem that, with respect that you're putting to me, which was this idea that surely Manala and Gowala are entitled to their 1/3. The answer is that they're not. And the reason, the fundamental reason we say that they're not, the fundamental reasons are two. The first is it was a unitary investment, and therefore that monies couldn't be invested anywhere else, and if they were invested anywhere else, then that profit would be removed from them rather than given to grantee as a prophylactic or deterrent operation of the rule. And it is particularly, so it's the singular nature of the investment and the fact that the rule operates to deter fiduciaries from breaching their duties. And
It operates to deter a fiduciary from departing from his or her obligation of single-minded loyalty to the principal.
well, that's one of the
It wasn't
examples.
Single-minded loyalty.
Yes, that is one.
Not said grantee could never have expected single-minded loyalty because it never had 100% of SMI.
No, but with respect, that's the incorrect, we would submit that that's the incorrect way of phrasing the duty. The duty is not single-minded loyalty. The duty was only to use the funds for a particular investment. Once you breach that duty, there is profit made. Now, it's no good awarding the profit that comes to grantee in any event to grantee. That has no deterrent value at all. That would mean, in fact, that there was no sanction for that breach of the fiduciary duty at all. The only way that the sanction works is if all the profits from the unauthorized investment are attributed to the principal.
I think if this, as used according to your researchers, is the first time that a court will be considering how fiduciary duties and the duty to account for profit should apply in a situation like this,
Yeah.
we will then need to do what we think is most consistent with the general principles underlying the duty to account.
Bearing in mind, with respect, that the principles are that where there's a breach of a fiduciary duty, there should be a deterrent or prophylactic result.
Well, you see, I think this is partly where the confusion comes in, because you say where there is a breach of the duty, then the prophylactic comes in. But the duty to account for profit is not the consequence of a breach of a duty. And I'm not aware of any proposition that says merely because of some breach of an obligation the fiduciary bears, there's a duty to account. There are two circumstances in which there's a duty to account. The one is where you receive something by virtue of your office, which if you received it at all, you were expected to receive only for the benefit of your principal. That's the profit rule. And there's the conflict rule, which at least now you appear not to place particular reliance on. There is no rule that if you breach some other obligation, the consequence is a duty to account. Of course, the breach of another obligation, and I apprehend you are talking here about undertaking the Cape Ghana transaction without the approval of grantee. It was unauthorized in that sense. That was a breach of the February 2005 contract. Perhaps it was a breach of a fiduciary obligation, but it doesn't follow that the remedy for that breach is that any profit that is made in consequence of the breach has to be surrendered. It may be that for that breach, your only claim, if it causes you a loss, is to sue for damages, which weren't suffered here, but that would be a remedy. We mustn't allow the accounting of profits to, as it were, be a remedy for everything in every fiduciary relationship. So we'll come back, at least on my understanding of authorities on the profit rule, to ask whether the benefits of the Cape Gannet transaction were benefits of a kind which, if Jawala and Manala caused them to be made at all, they had to make them for the sole benefit of Grand C.
Yes.
That seems to me to be obviously wrong.
That is wrong, and that's not our proposition. Our proposition is that where the breach of the duty is directly related to the making of the profit, as it was in this case, we say it was indeed their fiduciary duty to invest the pool of money only into the spearhead investment. Therefore, investing it into another investment was a breach of that fiduciary duty, directly related to the earning of the profit.
It didn't result in assets coming into the hands of Jawala and Manala, which were assets which, if they acquired them at all, they had to acquire solely for Grand C.
No,
that underlies the profit rule.
Well,
The definition of a breach explains why they should be liable if it caused Grand C a loss. It doesn't explain why they should have to surrender the profit, the 2/3, which it was always known they would get.
no, they wouldn't get it because they couldn't invest.
Their own interests as well as Grand C's.
No, they couldn't invest because otherwise you would reason on this basis. You would say that insofar as Giwala and Manala invested in the Cape Gannet investment, they did so in thirds, essentially. And there's nothing wrong with the investment by Giwala into this Cape Gannet because he had his own sum of money and he could do with it what he wished, and Manala similarly. But where it came to Giwala, they couldn't do that. That's simply, with respect, that's the incorrect reasoning because it splits up this pool as if it were three, and in fact then makes it not an unauthorized investment at all because they can do what they like with their own money, and that, we say, is not what they were entitled to do. They were obliged, sorry, Peter, they were obliged in terms of the spearhead investment only to invest in spearhead. And when they stepped out of that realm, they stepped into the unauthorized area. And once they're in the unauthorized area, our submission is that the rule holds that they must disgorge all profits made from an unauthorized investment.
Well, I think in the absence of authority, what you say is that the logical or an analogical development of the rule to this sort of situation should have the consequence for which you contend.
Yes, that's all I can say. And with respect, I would emphasize that the danger with what I understand you to be putting to me, Justice Rogers, is exactly that, is once you treat it as if they have the authority to invest their own part of the funds, then you're actually coming to a conclusion that doesn't exist on the facts.
Thank you.
As you please.
Yeah, it's me. I've been listening to your debate with Justice Rogers, and the point that I need clarification on is whether the fact that Grancy got a benefit to this transaction matters at all.
No, with respect it doesn't, and that does flow. The fact that it got, we would submit there may often be situations where the principal receives a benefit from the unauthorized investment. That wouldn't preclude it from claiming the profits that flow from that investment.
So basically the principal would get and keep the profit, but would challenge the fact that the transaction itself was unauthorized.
Yes. Unless the only way it would work otherwise with respect is if the keeping of the profit could in some way be determined to be a waiver of the right to hold up the fact that it was an unauthorized transaction. So it would sort of be acquiescence or waiver, and I did raise those. And that would have been an interesting point to debate, is whether in accepting the profits, grantsee also accepted the unauthorized investment and therefore can't be said, it can no longer be said to be unauthorized. But that would be a clear case of waiver, and it would have to be pleaded, and there would have to be all sorts of facts elicited in that regard, and that didn't happen in this case.
Thank you.
Justice Rogers, sorry, I don't have the exact reference, but I'm instructed that in the Rukadze case, the UK Supreme Court expressly rejected the kind of causation limitation that you referred to. I can't take you to that passage, and it's a very long judgment.
I read the Rukatsi case clearly. Yes, they did. The majority rejected a causation argument, saying it wasn't open to a, let me call it a pure fiduciary, whose duties were owed solely to a principal.
Yes.
To argue that
I accept that.
That if I had not reached my duty, if I'd come and sought consent, you would have given.
Yes.
The majority said that's not a legitimate
that is
kind of
correct.
reasoning, but they weren't dealing with the divided loyalty.
I accept that.
Mr. McNally, just one question from my side. You rely on the proposition in Symington that where there's a breach of a fiduciary duty, then the party breaching it is not allowed to benefit from that breach, correct? That's one of the principles that you...
Yes.
And on that basis, you take the position that you do in this case, that the rule has to be applied rigidly and in an uncompromising way, and understandably so. The SCA and the High Court had found that at some point, grantee became aware of the Cape Gallant transaction, and that they neither objected to it nor demanded that Ngatana dispose of the units acquired through that transaction. In your engagement with Justice Rogers, you indicated that, well, unless a waiver was pleaded and you satisfied the requirements of waiver, then their knowledge and their failure to object would have no consequence.
That is our submission, yes.
Right. So would your submission also then be that despite the knowledge and despite the failure to object, that the breach of a fiduciary duty was ongoing, or can it be suggested that to the extent that there was a breach of a fiduciary duty, once grantee had become aware that there was a breach of such a duty and did nothing about it, it would really be artificial to suggest that the breach of that duty continued to be ongoing from that point onward?
I hear the point, Justice Colopin. My response would be that it's not a question of an ongoing breach of a fiduciary duty. The breach was the investment in the unauthorized investment. Once that had taken place, the no profit rule comes into play. What happens thereafter is a matter of some complexity, but I would stand by the submission that says that insofar as grantee doesn't set us, and I would submit that in many situations the principal is entitled to ratify I accept these are different situations. They're often situations where there's a single duty, but the principal is entitled to ratify the conduct or the contract that comes into being as a result of the unauthorized action. It's not obliged to step back from it. It would be a question of whether that constituted a waiver. And I also would like to add that while it's correct that grantee did continue to receive the profits, I'm not certain it can properly be said that it failed to object. It sought to establish the facts behind the Cape Gannet investment for a long time, and the evidence of Mr. Mauji in cross-examination was that until the time of the particulars of claim, Grancy had still been pursuing the facts about that investment. So there wasn't a case of it being able to pull out, as it were, or insist on the Ingatana investment being undone prior to that. And furthermore, it has consistently been the attitude of Mr. Giwala, certainly, and Mr. Manala, that this was not an unauthorized investment. And so if Grancy had said, you must pull out of this investment, the answer would have been, well, we don't have to. There's nothing wrong with it. It's not an unauthorized investment. They insisted that it was unauthorized to the bitter end.
Yes, but Grancy had a different view, did they not?
Yes, no, they did.
Clearly, their view was that if it...
But it required, they couldn't themselves put an end to the investment. It required that to be done by SMI, which required then the cooperation of Messrs. Giwala.
There was no demand on their part that should happen.
No.
Thank you, Mr. McNally.
Thank you, Ms. McNally.
Thank you, Deputy Chief.
The court will adjourn for 20 minutes.
indiplum. Additional interest for the reasons stated in Drake-Flemmer imposed in terms of section 2A5 is different. The applicants argue that indiplum does not apply to the proceedings for a statement and debate of an account. There is no authority of which we are aware in our law that supports that, and they have not pointed to any. They argue in the alternative that the common law should be developed so that indiplum should be suspended from when an accounting is sought. Now they say it should preferably be when an accounting is due until it is produced. We submit that there is no basis for developing the common law in this way. The indiplum rule is of general application. The nature of a particular type of proceedings and a concern that there may be delaying tactics is no basis, we submit, for introducing a new rule that in all accounting proceedings of whatever kind, indiplum should not apply. It would be consistent with this court's decision in Paulson that indiplum does not apply to an accounting which is also in the nature of proceedings pendente lite. As far as the question of whether or not the Sharig and Spearhead debts are liquidated or unliquidated debts are concerned, in both the Spearhead and Sharig agreements governing the investment, they fixed the date when the debts were due, and that is why Mora X Ray arises from those agreements. But they also set out, with reference to the terms of the agreement, how the debts should be determined. So, for example, in the Sharig agreement, in relation to additional option shares, in paragraphs 44.5 and following of the particulars of claim, the time for performance was fixed. The grantee was to participate equally with the other investors in acquiring the shares. The net proceeds of the grantee portion of the Sharig shares, after deduction for costs, expenses, and the Gawala's 25% profit share, would be paid as soon as possible after the grantee portion was realized. It provided the components for the calculation relating to the additional option shares. And they are the number of additional option shares, the sale price, R5.75, as found by the SCA, the cost of the shares, which was not in issue, of 2.2918 Rand per share, and the DGFT's 25% profit share, which was not in issue on the pleadings. And that is the simple calculation that one finds in the particulars of claim at paragraphs 50 to 56. And it appears from the High Court judgment at paragraph 340 to 342 and the Supreme Court of Appeal judgment at paragraphs 121 to 122. And in the particular circumstances of this case, the Shari claim for additional option shares was unliquidated. Was liquidated. We should address one point that is made, and that is that Grancy says that it was unable to determine what was owing to it until after the accounting. But the real question is, it is the knowledge of the debtor, the Gawala respondent, not the creditor, that is relevant for these purposes. The rationale for the distinction between liquidated and unliquidated debts and the running of interest is that a debtor is liable for interest on a liquidated debt at common law only when it knows or can ascertain the amount it has to pay. Now, when the applicants brought their accounting proceedings in 2007 and 2008, they did so on the basis that the Gawala respondents knew or were able to ascertain what was owing and they should account for it. And in those circumstances, the Sharig additional option share claim is a liquidated claim. The applicants rely as well on Section 2A of the PRI on the basis that the debt is unliquidated. We have an already addressed argument as to why interest prior to judgment in terms of 2A is arrear interest subject to indiplum. There was very little, if anything, said in the course of oral argument about the discretion to override the indiplum rule in this case. We have made the submission in written argument that Section 2A5 is expressly subject to any other law, and that would include the common law, as is indicated in the cases referred to in paragraph 45 of our heads. So the PRI is to be construed in conformity with the common law, except where there is a plain intention to alter the common law, and there is no intention that the legislature intended to modify the common law law of indiplum by the provisions of Section 2A5. 2A was intended to alter the common law to permit interest on unliquidated debts. For the reasons advanced in our written argument, there is, in any event, we submit no basis for the exercise of a court's discretion under 2A5. The applicant place all the blame for the delay on the Gawala respondents, but that is unfair. Much of it is as a result of the ordinary course of litigation, including, by way of example, the litigation relating to the two-stage judicially controlled debatement, and following the 2016 accounting, the litigation that has continued to date. The Cape Gannet profit claim is advanced in paragraph 40 of the particulars of claim on the following basis. The Cape Gannet transaction was contrary to the spearhead agreement because the applicants did not consent. The Gawala, the DGFT and Manala made and will continue to make a profit, which it is pleaded is the amount of the financial benefit flowing to Ngatana, which is distributed to Ngatana's shareholders, and then, I quote, multiplied by 0.58 and then multiplied by 0.6666. That represents the profit that the DGFT and Manala made by virtue of their 1/3 shareholding in SMI and SMI's 58% shareholding in Ngatana. Grantie's claim is based on the equitable remedy of a claim for profit and on the remedy for a claim for a declaratory order, which under Section 19(1)(a)(3) of the Superior Courts Act is discretionary. The history of the acquisition of the spearhead units, the conversion to redefine units, and the acquisition of the Cape Gannet additional redefined units is described in the judgment, and it's unnecessary to take the court to it. The general legal principles applicable to a claim for profit are stated in Robinson versus Ranfontein at 177 to 178 and at 179, in Phillips versus Fieldstone, which highlights the approach followed in a leading English decision of Boardman versus Phipps, one considers the facts of each case to establish the scope and ambit of the duties of the fiduciary, and whether he or she has placed themselves in a position where the duty may conflict with the interest. And if accountability is established, it only goes so far as to render the fiduciary accountable for profits within the scope and ambit of his fiduciary duty. We take the point that in our law, a distinction is drawn between the no conflict and no profit rules. Rudakazi, in the recent Supreme Court decision, describes the profit rule as being closely related to the no conflict rule, but both serve the same prophylactic purpose. Grancy, the DGFT, and Manala had the same interests. A 1/3 entitlement to profit by virtue of a shareholding in SMI in respect of profit that SMI derived from Ngatana arising from the additional defined units. That structure reflects what the SCA in the 2016 judgment described as the principle of equality and parity of treatment. So when the DGFT received their 1/3 profit, whether in respect of an authorized transaction, such as the spearhead units, or an unauthorized transaction, such as the acquisition of the additional redefined units, it does so by virtue of its own interest. It doesn't do so within, to use the language of Phillips, the scope of its authority, the scope of its duty as a fiduciary acting for Grancy. The profit that it receives by way of a 1/3 share is not in law deemed to be Grancy's profit. And in those circumstances, the profit rule finds no application. Thank you.
Thank you, Mr. Rose-Innes.
Mr. Rose-Innes, just on the question of interest and whether Section 2A5 would permit a court to override indiplum, I might have been wrong in Greg Flemmer, and you are welcome, obviously, to submit that I was. But the question, having reread what I wrote a few years ago, I left open the question whether subsection 2 applied to damages for breach of contract such as occurred in that case. But in regard to subsection 5, which was the provision I found should be applied, I said the interest that the court awarded in such a case was not a rear interest because by its definition it wasn't running under the law at any earlier date.
Yes.
It only became owing there and then. So that if, for example, the capital amount was 2 million rand and the court thought it just and equitable that on that previously unliquidated sum interest should run from, should be awarded from a certain date, and under subsection 5 awarded interest that came to 3 million rand, that would be permissible. And in fact, that was the outcome
Yes.
of Craig Flemmer. Do you submit that that was wrong or
No.
distinguishable?
No, neither. We accept that that is a consequence of the exercise of a discretion under 2A5 to allow interest for an earlier period.
So you say it wouldn't fix
Which
the
it-
period to which subsection 2 applies?
It doesn't a clear distinction between the earlier period and the 22A period. Interest runs under 22A, more interest, more ex lege arising from the provisions of that section, which is subject to indiplum. The 25A additional interest is not a rear interest, and that is why it can accumulate in excess of the capital as it did in that case.
It doesn't even accumulate, it is just awarded.
It's just awarded. Our submission was,
Be expressed as a period, but it's practically awarded at the date of the exercise of the discretion.
our submission is perhaps not put as clearly as it should have been, that what can't be done, as we understood the applicants to argue, is in the exercise of a 2A5 discretion, that a court says, in the circumstances of this case, I find that the indiplum rule, which is ordinarily applicable to the interest in question, should not apply. We submit that the,
So you mean under subsection 5,
yes,
the court can't render indiplum inapplicable to the subsection 2 interest?
exactly.
Just one other question on whether the claim, I think this will apply to the Scarrig case, was liquidated or illiquid. You say the emphasis is on when the debtor can ascertain what his or her liability is. Now, if in the case of the Scarrig claim, a necessary component of ascertaining the amount was to know when Grancy would have sold the shares, how did Mrs. Gawala and Manala know that?
Well, Mr. Kawala knew that in January of 2006, Grancy shares were sold.
Yes, I think that happened without Grancy's knowledge,
Yes,
and at a price which Judge Ragg said that Grancy wouldn't have accepted if it had known about it.
yes, but,
It
and
was below the market price.
that claim didn't, that claim did not succeed before the ACA. But Mr. Kawala knew that there was an opportunity to sell shares at that stage, and knew what the market value was at that stage. I can't take it any further than that.
I appreciate that it's important that liquidity may require inter alia that the debtor should be able to reasonably ascertain what his liability is. And that is usually the aspect that will be missing when a claim is brought. But do you say it's irrelevant that the plaintiff itself couldn't ascertain? I know you say that on these facts the plaintiff could ascertain, but as a general proposition, it seems to me difficult to say that if the plaintiff couldn't ascertain what the amount of the claim was, that the defendant nevertheless could, because it had secret information. It somehow strikes me as a rule that is there for the protection of the debtor, that it shouldn't be saddled with interest where it doesn't know the amount of the liability, should become a weapon of injustice against the plaintiff who doesn't know the extent of the liability.
Yes, we don't go so far as to say that it would be relevant in all cases. It depends on the debt in each case, and to take the additional option shares, a debtor would, upon a receipt of the grantee particulars of claim in this matter in 2016, at least at that stage have been in a position to determine what was due, and for that reason the particulars of claim would constitute a demand, if not a summons.
You quoted the phrase, I think it comes from one or more cases, that the extent of the liability to account for profit is profit within the ambit and scope of the fiduciary duty. And I understand you to apply to the circumstances of this case to say that the ambit and scope of the fiduciary duty that Manala and Jawala owed to grantee was in relation to grantee's 1/3 interest in SMI. Is that
Well, in relation to grantee's profit, which flowed from
Yes.
its 1/3.
Are you in the same position as your colleagues, as having looked for and been unable to find a case where the fiduciary was at the same time a co-shareholder who inevitably had its own commercial interests in the transactions in question?
Yes, we are.
Any-
We've not found anything, and the court stated, as you would know, that the profit rule is easy to state, difficult to apply at times, and particularly where there isn't, we found no guidance from any other case on the facts of the present matter.
Thank you.
Thank you, Mr. Rodriguez. Mr. Bolo? I don't suppose you need the whole 30 minutes.
Sorry, my lord.
Do you need the whole 30 minutes?
I don't think so, because a lot of what's been said by Mr. Rose Inez has been said and affects our client as well.
Okay.
Mr. Manala, the second respondent. I think the starting point is that Mr. Manala has got no involvement whatsoever in the Sharig matter. So the net effect of that, and I'll start with indiplum, is obviously number one, that to the extent that my learned friend Mr. Rose Inez has argued on behalf of the Giwala respondents, we align with his arguments, both in regard to the fact that the debts in question are liquidated clearly in the Spearhead matter. There can be no question about that. And in fact, if I may briefly read from the judgment of Acting Justice Ragg, because it does crystallize why we say, one, that the claim against Mr. Manala can never ignore the provisions of the indiplum rule because it relates clearly to liquidated claims, and that is to be found at volume 21, at page 2034, paragraph 372 and following. Acting Justice Rad says, I have found that grantee is entitled to judgment for the capital amounts related to the Spearhead transaction 4. Non-payment to grantee of its full entitlement to dividends declared by SMI arising from grantee's additional 2.33% shareholding. There is a mathematical calculation that could have been done without any statement of account. And this goes to the second point, that a statement of account and a debatement of account cannot be just of itself something that suddenly gets us away from the indiplum rule. It must at the very least depend on the type of claim. In other words, Was the statement of account necessary? Did it have to take so long to ask for the statement of account? Could Grand C have had access as a 31% shareholder in the company since 2009 to documents, auditors, bank statements? Could they have asked us in terms of PIA or all kinds of other provisions available to them to get documents and do their own accounting of the 2.33% that hadn't been given? By the way, the 2.33% was kept for another very good reason away from Grand C, because they were an overseas shareholder getting involved in a BEE transaction. And 33% and a third percent would have contravened matters, but I won't labor that. The point is the first one. The second finding, interest on the sum of 10 million that was deposited in HHG's trust account. Again, very simple thing that could have been obtained by Grand C much earlier, and which militates against saying, well, hold on, there was a delay, and therefore because there was a delay in the accounting process, I'm going to ignore indiplum. And in fact, the Supreme Court of Appeal made that very point. Perhaps I don't have to read it. In one of the paragraphs of the judgment handed down by the SCA is clearly stated, many of the delays were delays that would happen in normal litigation. By way of example again, McDougall J made a ruling to say a debatement and statement of account can take place as follows. The parties could have rested and done that, and it could have worked. The appellant, as it's entitled, do approach the Supreme Court of Appeal, but we know that hearing could have been a year away, it could have been 2 years away, through no fault of Mr. Manala, for example. And the method used in waiting for that statement of account to be finalized and litigated and appealed could be one of the causes why there was a delay. So the mere point of saying, well, there was a delay by the respondents isn't accurate. Another example, the Sherrig matter took at least double the time to prosecute and to finalize in the courts before, for example, Deputy Judge President Traverso, she then was, Acting Judge Reg. The time devoted to these matters was not proportionate. So Mr. Manala's faced with a situation where his case was consolidated. We weren't part of the matter when it was consolidated. We in fact considered bringing a separation, but be that as it may. The point being that those delays are attributable perhaps, insofar as the Spearhead matter, in some measure, to the Sherrig matter being so complicated, so document intensive, and so difficult to finalize, with claims which were arguably unliquidated. I'll leave that to the court and my learned friends to argue about. And so goes the RAG judgment on various other claims that, if you look at them, are all purely liquidated. If that's the case, and looking at the PRI and Section 2A5 and the juxtaposition with Section 2.2, it's clear that in the Spearhead case, there's no room to say, unless you develop the common law, or unless you find that a statement and abatement of account is a matter that's different, that somehow interrupts things. But we would argue two things. One is the fact that it was found that the development of the common law wasn't properly pleaded is sacrosanct. It doesn't matter how many times my learned friend Mr. Hodes canvassed the matter in argument before Judge Ragg and before the Supreme Court of Appeal. The fact is it wasn't a pleaded issue. We weren't able to lead evidence, for example, on the issues I was dealing with earlier. Who caused what delay? And we weren't able to put before RAG AJ the fact that before Traverso DJP, for example, the Spearhead matter was unduly delayed, and you don't develop the common law to give such a blanket decision that can be made by a court to say, well, whenever there's a statement of account for debatement, we're always going to ignore induplum. And those, I think, are our submissions on induplum, in addition to aligning ourselves with my learned friend, Mr. Rosines. The Cape Kenneth situation, and I think with respect, the Honourable Justice Rogers touched on the very big problem that the appellants have, but that problem hasn't been fully even expounded during the course of these debates. And reference must be made there to Volume 1, where's my Volume 1? sorry, just lost my train of thought for a second. Volume 1, page 60. In fact, page 58 is the start of a document which is the shareholders' agreement of Ngatana. Remembering that Spearhead owns 50% of Ngatana, and if one has a look at the front page of, SMI owns 58% of Ngatana, and if one looks at the first page of the Ngatana shareholders' agreement, one will see that SMI is one of the parties, and that Hofmeyer, Herbst Giwala prepared this document. In fact, before RAG AJ, Mr. Mauji conceded to me that he was well aware of this document. Now, the relevance of this document is if one goes to page 66 at clause 3, it says the company, that's Ngatana, has been established with a view to acquiring the Spearhead units, and then it goes on, and to pursue other opportunities in the property sector. So Ngatana, the company in which Grancy had an indirect interest, and perhaps contrary to the Spearhead agreement. However, we did argue to both RAG AJ and the Supreme Court of Appeal that the Spearhead agreement could not have had a preclusion on other property investments because of this very clause in the shareholders' agreement. But let's leave that aside. Let's assume that it's a breach of the Spearhead agreement for Ngatana to even be a party to this clause that says that it can enter other property investments. Now you have a situation where Mr. Giwala and Mr. Manala, as directors of Ngatana, have obligations also to all the other directors of Ngatana and also to the company itself. One of the obligations is to seek out other good investments in property in South Africa. These new units that were purchased, called the Cape Gannet, are that very opportunity for Ngatana. And let's make no bones about it. Grancy had no chance whatsoever of ever benefiting from this opportunity, except in the way that they have. They couldn't have bought these units. You needed a BEE company like Ngatana, first of all. Secondly, according to them, they didn't want to be in anything but Spearhead units. But they got themselves into a company that was bound to a shareholders' agreement, which they never questioned. They never set the agreement aside. They never tried to set aside transactions concluded. The bottom line being that they really sat back and said, well, here's the investment. We'll see what happens. We've seen what happened. They profited from it. Again, this is not a fiduciary, Mr. Manala, for example, who goes and says, I see we can get these units. I'm 100% a young black engineer. I can get these units for myself. I'll find a financier, or I'll use Ngatana's monies. I'll get these shares for myself, and I'll divert the business opportunity. What he does with respect is the honest thing. He gives the opportunity to Ngatana, which is allowed to, in terms of its own shareholders' agreement, invest. It's one of its main objects, clause 3.1. What he then does is procures that Ngatana then distributes dividends, and they're receiving them even into the years. So SMI is receiving dividends from Ngatana from these very units through all the years. Now you say, well, but don't Mr. Giwala and Mr. Manala then profit from this? Well, no, because they've got to first wait for dividends to be declared by SMI to get their money out. And it's not at the expense of anybody. It's actually to the assistance of both SMI and Grancy that they were able to make good on this lucrative investment. Now you say, well, could they not have said to Grancy, we want to invest in this in Ngatana? And what would they have done if Grancy said no? They would have then prejudiced Ngatana. They acted contrary to their duties to their co-directors in Ngatana, and acted contrary to the interests of the shareholders of Ngatana, not only 58% SMI, but all the other shareholders. So maybe they were between the proverbial rock and a hard place. But the bottom line is, they didn't profit for themselves. They profited for SMI. Of course, a fiduciary who's a shareholder of a company also profits himself or herself when that company goes into an investment. But the aim wasn't to divert a business opportunity as is alleged. The aim wasn't to profit personally, but rather to make the bigger good, the SMI, profit, and of course indirectly profit, but isn't that what every shareholder and director who's also a shareholder does? Aims to profit for the company. So we would say that this doesn't have the hallmarks of any of the cases that we've been referred to, and that with respect, Justice Rogers' concern where there might be a different type of duty between Mr. Manala, Mr. Giwala on the one side, and Grancy comes to roost. It's actually they had to act in the best way possible while following the remit of Ngatana. And you don't then say, well, if Mr. Mauji had come forward and said, well, I didn't know anything about that shareholders agreement, I wouldn't never have agreed to it, but his own attorney, Grancy's own attorney, Mr. Giwala, drew it up. Hofmeyr, Herbstein, Giwala, who they channeled all their monies through in order to get them ultimately to SMI and Ngatana, represented them at the start, not after there was an advertisement of this transaction, from the start. So with respect, and I haven't taken you, but I think you've all read the various, and it's in Mr. Manala's founding affidavit as well, the various sequences of events that took place in the purchase of these units. They're all indicative of someone, at least at that time, being Grancy, not being so unhappy about what's happened. What they then do, of course, is later when they sue and they find that they're at loggerheads with Mr. Giwala and Mr. Manala, they say, well, let's throw this in as well. It's similar to the indiplum, I think to the indiplum claims. I think the SCA remarked that Grancy has at all material times tried to claim every single thing that they possibly could. Now, of course, I'm not saying my learned friends mustn't claim what might be rightfully due to them, but this seems like they're going a little bit too far. And there is no conduct on the part of Mr. Manala in particular, and we don't encourage Mr. Manala and Mr. Giwala to be coupled on the tote. Mr. Giwala was the respected, revered, very experienced head of HHG. Mr. Manala was the young, up-and-coming engineer who brought a very big and lucrative BEE deal to the party and put his hands in Mr. Giwala's, put his future in Mr. Giwala's hands. That being the situation, if you do believe that there's room to say, well, Mr. Giwala was at fault for whatever because he was the driving force of all the accounting, remembering that the Supreme Court of Appeal and Acting Judge Ragg found that Mr. Manala was not in contempt of court when he failed to account because he said, I can't account. Mr. Giwala's got all the documentation. I couldn't improve on Mr. Giwala's accounting if I tried. That's been upheld by 2 courts of law, and we would submit correctly so. So if there is room to say, well, Mr. Giwala tried to profit, there certainly isn't room to say that Mr. Manala tried to profit. Those are submissions. Thank you.
Thank you, Mr. Mbolo. Thank you very much, Mr. Mbolo. There are no questions for you. Reply, Mr. McNally.
Thank you, Justices. Firstly, dealing with our learned friend's submission about liquid or unliquid or illiquid claims, the court will now understand that our fundamental submission is that claims which are based on, sorry, it's a bit distracting. Claims which are based on a statement and debatement of claim are fundamentally, we say, unliquidated claims. It is in the event that and then it follows that because they're unliquidated claims, we would submit that arrear interest doesn't run on them or they don't attract arrear interest. And we say that the induplum rule only applies in the case of arrear interest, and therefore the induplum rule doesn't apply or shouldn't apply in relation to statements and debatements of account. Now, our learned friend made the point that we don't provide authority for that, and it's correct that we don't provide authority for that specific submission. But it is, we say, the natural progression of a number of other findings that have been made by the courts. The findings being that arrear interest doesn't accumulate on an unliquidated debt, and that indiplum only applies to arrear interest, and therefore it doesn't apply in circumstances of a statement of claim. If we're incorrect on that, we then say that in relation to Sharig, it must be accepted that that claim is unliquidated. Now, my learned friend says, no, it's a matter of simple calculation, and he says, just look at the particulars of claim. There was a simple calculation. It wasn't a simple calculation, it was the method of coming to a number, which turned out to be completely wrong, as it turned out, as often happens in particulars of claim. It wasn't capable of ascertainment because the number of additional shares was not known. The sale price of those shares was not known. Those had to be hypothecated by the court, and they were hypothecated. In fact, they were hypothecated differently. Hypothesized. They were hypothesized differently by the High Court and the SCA and in the particulars of claim, because they were not facts. They had to be determined by the court. That is, in a sense, the very definition of an unliquidated claim. So our submission is that either the entire claim must be treated as an unliquidated claim on the basis that it is pursuant to a statement and abatement of account, and we have set out in our heads of argument how that claim developed through His Lordship Mr. Justice Claude Law and His Lordship Mr. Justice Binns Ward, where at the time that an account was claimed, all that was claimed was whatever it is that turns out to be due. My learned friend speaks about the knowledge of the debtor. Our submission is twofold in that regard. The first is to say that in cases such as this, it can't be the knowledge of the debtor that's important. It must be the knowledge of the creditor, because it is the creditor that must formulate the claim. But we go further, and we say that the Giwala respondent's argument that Giwala knew how many shares he had withheld from Grancy, and therefore the claim must be liquid and subject to induplum, disregards the fact that the number of shares is but one component. Remember, in any event, the number of shares was denied by Mr. Giwala throughout. But let's say, theoretically, he knew what he should have made available to Grancy. That is but one component. What is still unknown is the selling price and the sale date, and those had to be, is it hypothesized by the court? It's a matter of value judgment. And secondly, Mr. Giwala, in fact, at no stage accounted on the basis of this knowledge that he now professes he had all along regarding the number of shares he received. He steadfastly maintained, this court will recall from the judgments throughout his accounting, that there had been a proportional allocation or proportionate allocation of Sharig shares, which in fact was completely wrong. Yet that was the version he held on to throughout the entire matter and during the hearing itself. So our submission is that it can't be suggested that because Mr. Giwala notionally perhaps knew what he was concealing from Grancy, therefore the claim can be considered to be liquidated. It's been suggested that little has been made by us in argument of the section 2A5 point that's raised in our heads of argument. We do say that the section 2A5 point becomes less relevant if this court accepts that unliquidated claims do not attract arrear interest, and Grancy's claim is unliquidated because it's based on a statement and abatement of account. But to the extent that the court's not with us on that contention, then we do submit that section 2A5 remains relevant. Grancy at all times claimed interest on its unliquidated claims from a date before date of demand. So it always relied, as a matter of fact, on Section 2A5. And interest on Section 2A5 amounts, additional interest, is per Drake Flemmer, not a rare interest. The High Court and the Supreme Court of Appeal have ordered that interest run on the Sharig claim from 25 January 2006, the notional date of sale. There's no cross-appeal against that being the date from which interest should run. And we would submit that given that, on our argument, the Sharig claim is unliquidated, the interest on that claim from a date earlier than demand can only be interest in terms of Section 2A5. And if that is the case, because interest in terms of 2A5 is not a real interest, then it's not, the award in respect of Sharig cannot be subject to the indiplum rule. Our learned friends for the Gewala respondents make the point that the no profit rule is based, as it indeed is, on the equitable rule in English law, but he didn't go further, as they do in their heads, to suggest that the rule applied in friend says that the Section 2A5 discretion doesn't permit the court to avoid induplum where it's otherwise applicable. And he says that 2A5 is subject to any other law. And he says, well, any other law includes the law of induplum. But of course, that doesn't take into consideration that 2A5 applies to unliquidated debts and induplum doesn't apply to unliquidated debts. So applying any other common law in relation to 2A5 is not that induplum applies. Then finally, just to deal very briefly with my learned friend's point about Section 3.1 of the Shareholders' Agreement of Ingatana, the fact of the matter is that the SCA has made findings in respect of what the Spearhead Agreement was. And one of those findings is, without question, that investments could only take place in the Spearhead Agreement. And therefore, any investment outside of Spearhead was an unauthorized investment and a breach of the fiduciary duty. Those are our submissions. In reply, you have asked for a schedule to be produced by us. I think Justice Rogers asked for that schedule. Can we suggest that that be provided within 5 days of today? Is my last submission.
That would be in order, yes.
As you please,
5 days.
Chief Justice.
Okay. Thank you very much.
I do apologize. Can I just give the court a couple of references which are important in relation to the question of error of law in relation to jurisdiction? I do apologize. I'll take 2 minutes. Just dealing with our application, if I can refer to page 1791, paragraph 20.2, 1794, paragraph 24, 1799, paragraph 36, 1802, paragraph 42.1, and 1794, paragraph 23.3. Those are instances of where we make it clear that we're not only suggesting that the SCA misapplied the law, but that it committed an error of law which this court should set right. I apologize for going over the time.
Thank you very much, Mr. McNally. Thank you. Judgment is reserved. Court adjourned.